Estate planning topic, counseling issues. I previously referred to getting good personalized counseling as an important key to every good estate plan. In this video clip, I'm going to give you some of those counseling issues that we go through with our clients. Number one, catastrophic illness protection. What that means is, and I'll just, in a form of a question, I'll ask our clients, if you were to have a catastrophic illness towards the end of your life, stroke, Alzheimer's, a mental disability, do you prefer to live at home or be put into a nursing home? Do you have an opinion on that matter? And most of our clients have a very strong opinion on that matter. They prefer to live in their primary residence as long as it's practical and feasible. But where in the legal documents does that go? And most estate plans that I review, it's not really clear where that goes. And we want to make sure, if that's something that's important to you, that is clearly laid out for your helpers, your family members, your loved ones, so that they know what your wishes are and now how to coordinate the finances to make that happen. Most people, what they'll do is they'll create an advanced medical directive, they'll designate a healthcare agent, give them a list of powers, and let them figure out what to do. And from my personal experience, I think that's a very difficult issue to leave to the family. My dad had Alzheimer's, and he didn't tell us what he wanted to do, and it was really tough for us to go through those issues. Number two important counseling issue is remarriage protection. Sometimes I don't see this addressed as much in most estate plans, but once I counsel our clients through it, almost everyone is very interested in this planning option. So remarriage protection, I'll introduce you to my first cast of characters, and yes, I do use stick figures, but the point is this. Most estate plans that I review, they'll have what's called the I love you wills. And the I love you will works something like this, where we have Bill and Mary sample, and if Bill were to predecease Mary, and in our estate plans, we always have the guys checking out first or passing away first. You can do whatever you want in your plans, but so we're just going to say for Bill, once Bill passes away, his will says that everything goes to Mary. And then when Mary passes away, everything should come down to the kids. Very common scheme in most estate plans, and if Mary were to predecease Bill, all of the assets would go to Bill and then down to the kids. It's called the I love you format. Most people know this situation. So let's play this out in the remarriage context. So let's say that Bill predeceases Mary, and all the assets go to Mary according to Bill's will. Well, let's say that Mary meets Bo the tennis pro, and they fall in love, and she gets remarried. So we're talking about remarriage issues. And let's say that Mary doesn't cooperate and predeceases Bo. So now we've got a situation where the assets went to Mary, Mary remarried, and now her will says everything goes down to my kids when I pass away. Now, even though her will says everything goes down to her kids, does Bo have a legal right to those assets? And in Virginia, Maryland, and all 50 states, the answer is yes. Okay, whether it's an augmented estate, an elective share, a spouse, even though they're left out of the will, can elect against that will, can create what's called an augmented estate and take the certain portion of those assets and still take those assets even though your will says that the assets should go down to my kids. So this is a very important planning issue to consider. Especially if the wife predeceases the husband. I find that the married men seem to be, there's a lot higher chance of remarriage as well, and we want to make sure that the assets come down to the children. Another important point when it comes to remarriage protection is that title will trump the legal documents. And what that means is that the way assets are titled will in fact control and actually trump what the will or the trust says, unless written properly. And so most people have on their IRAs the spouse as the primary beneficiary of an IRA. Well, if Mary remarried and Bo is the spouse in that situation, that may not be the intended result. Life insurance policies are also controlled by beneficiary designations. And so we have to look at who is listed there. And a lot of times we'll see the spouse. A lot of people will own their home or real estate as joint tenants with right of survivorship, or tenants by the entirety with right of survivorship, which means that when one joint tenant passes away, the asset will go to the survivor without any regard to what the legal documents say. So really important concept is that title will trump the legal documents. So we want to look through those counseling issues. So if there's a way that we can back up and do Bill and Mary's planning again, and so let's say that Bill passed away, but in the planning documents it said that I'm going to leave everything to Mary. She can use it for whatever she wants, but if she were to get remarried and predeceased, whatever the spouse at that point in time was, all the assets must come down to my children, regardless of any spousal elective share, augmented estate. That's an important counseling issue. And so most of our clients say, absolutely, I would want something like that to make sure that after I left my assets to my spouse, those assets must go down to my children, and barring any type of, or to prevent any issues that might occur if there was a remarriage situation. The third important counseling issue that we go through in our estate planning is creditor protection. And creditor protection is real important. A lot of our clients find this to be a very important issue. And the way I illustrate it is through what we call our school bus story. It's a very famous story in our firm. And the way that it goes is something like this. And I'll use myself as the example. So let's say that I've passed away, and now my 2 or 3 years later, after I've passed away, my wife is driving on a local highway, and she runs an intersection, bam, hits a school bus full of children. So if you heard the facts there, she was not paying attention, she ran an intersection, she ran a red light, let's say, and so she's going to be judged negligent, and now there's going to be some creditors or whoever was hurt in that accident. And let's make this the facts even more horrible. Let's say that one of the school kids actually got killed in the accident. And so the point of this story is just to illustrate creditor protection. And there's a couple different ways I could have left my assets to my wife, and there's varying degrees of creditor protection on that. So let's go through each one by one. So I could have left my assets to my wife through a simple will. And in the simple will, I could say, when I pass away, everything goes outright to my wife. Under this scenario, if I left everything outright to my wife, and then she hit the school bus, and then was sued by somebody, do you think those assets would be subject to her creditors? Absolutely, right? Everything that she would have in her name, that's going to be fair game if I was the attorney looking for those assets. Number 2 way I could have left my assets to my wife is through joint ownership. Joint tenancy with right of survivorship, tenancy by the entirety with right of survivorship. The way this type of ownership works is that if I were to pass away, so let's say I have my house and I pass away, we own it jointly, the house, the whole interest of the house would go into my wife's sole name. And let's say at that point in time she hit the school bus, could that, if there were a creditor's attorney, could he slap a lien on that house if he got a judgment? Absolutely. They could go after that house, go after those assets that would be all in her name, and that's fair game. Number 3rd way that I could have left my assets to my wife is through contract. So let's say that I have a life insurance policy. That might not be worth a lot while I'm alive. Let's say I have a term life insurance policy. But let's say it turns into $1 million when I pass away. And in that beneficiary designation form, I list my spouse as my primary beneficiary in her individual name. So when I pass away, she's going to get $1 million check delivered to her, and she's going to probably put that in an investment account or a bank account in her name. Do you think those assets would be subject to her creditors? And I'm going to answer that again, absolutely. They're going to be subject to her creditors, and that's a big issue there. So number 4 way is a trust. So you take the time to create a trust. I call it the bare bones type of trust, where there isn't many counseling issues being discussed. You maybe got it through on the internet or some word process type of document, but you didn't really go through that. But if the trust says, the terms of the trust actually say, when I pass away, everything goes outright to my wife. Again, you fall in the same pitfall where those assets can be subject to the creditors. Now, there's a 5th way you can do it, and I call it kind of our InSight law planning process, in that let's say that I could have done my planning again, and let's say when I pass away, I can leave everything to my wife. She could use it for whatever she wants, but if she hits the school bus, it will be protected from her later creditors. So let me say that again. I could leave my assets to my spouse or my loved one, whoever is important to me. They could use it for whatever they wanted, but if they hit the school bus, it will be protected from their later creditors. So I'll ask all of our clients this. How many of you would like to leave your assets to your loved ones that way, protected from later creditors? And I've found that a lot of our clients really find that important, but they haven't been asked that question before. So that's the difference between counseling and word processing, is that you don't have to select all the options. But you have to know what options are out there so we can go through them. And most people, once they are counseled on their options, they like to take advantage of those options. And a lot of times, those options don't cost any more money than having just a basic plan. That's creditor protection. The fifth way is, the fifth counseling issue that we go through is divorce protection. And I'm not going to spend too much time on this, and this is divorce protection for your children. And that how important is it to you, or how would you like to assure that the assets that you leave to your children or to your loved ones stays with them and don't go with any what I call outlaws or ex-spouses. And so there's ways that we can protect the kids' inheritance or your loved one's inheritance that if they were to get married and divorced. And I find that to be a really important issue. Fifth counseling issue that we go through is values promotion. Values promotion, very near and dear to my heart. In that I consider all of our clients, yeah, we have a lot of material wealth that we're transferring from point A to point B, but it's that non-material wealth that I want to look at, the values, the life lessons, the wisdom. And I'll go into more detail in our legacy videos, what we mean by values promotion. This has been Bobby Fazy, estate planning attorney with InSight Law, on important counseling issues for your estate plan.